RTI, Right to Information Act 2005. This was enacted in replacement of Freedom of Information Act 2002. Why? To keep the public authorities in check. See, in a democracy where we can elect our representatives, it's also important that we make sure whether they are working for the benefit of the nation or not. Through this act, you can ask for any information from the public authorities and they are liable to answer. Except there are some exemptions, as in information that public authorities can refuse to share with you. These are information that are related to sovereignty and integrity of the nation. The disclosure of such information could put these aspects of the country into danger. Other than that, you can ask anything that the government share with the parliament, including records, documents, memos, emails, opinions, advice, press releases, circulars, orders, logbooks, contracts, reports, papers, samples, models, data material held in any electronic form, and information relating to any private body, which a public authority can access under any other law for the time being in force. This act also makes sure that there is no corruption as the transparency of all the government related information is maintained. Of course, you cannot ask any personal information about a particular government authority, but you can keep record of the money that you pay through taxes and government promises to spend it on a certain project. You can ask them about the allocation of funds. RTI keeps the citizens informed for their correct vigilance over the public authorities. However, if you have to pay to get the information, you have to pay actually to get the information. When information has been sought concerning any state government department, then the applicant requesting such state department has to pay a fee prescribed by RTI rules formulated by the concerned state government. It is to be noted that an applicant, when seeking information from the concerned public authority, need not furnish any reason for requesting the information, nor is required to provide any other personal details, excluding those which are essential for contacting the authorities. But you might ask, how is it different from any other anti corruption act? See, when it comes to RTI, there are watchdogs on multiple levels to ensure the act is followed in letter and in spirit. The Act has employed a perform or perish approach besides setting up a mechanism to dispense information. Every government organization is needed to appoint one employee as a public information officer. Once a department gets an RTI request, it is the responsibility of the PIO to furnish the information to the applicant within 30 days. Failing to do so means a monetary fine can be imposed on the PIO. The longer a PIO makes an applicant wait, the more the penalty levied on him or her. There have been instances where PIOs have been asked to cough up amount in thousands of rupees as fine. Every state has an information commission comprising a chief information commissioner and a few information commissioners. Former judges, IAS, IPS, officers of impeccable record are appointed to these positions by the government. Above them in the hierarchy is the Central Information Commission, and below them are the first and second appellate authorities to see to it that an applicant does get the RTI information he or she has requested. What if you don't get the information you sought? In case the applicant doesn't receive the information sought for or is unsatisfied with the information so received, he or she may file an appeal with the first appellate authority as provided under Section 19, Clause 1 of the RTI Act. The first appeal has to be filed within 30 days of receipt of information or within 60 days of filing the RTI application, where no information is provided within the prescribed time limit. Further, suppose you do not receive information even after filing the first appeal or aggrieved with the first appellate authority order. In that case, you can apply for a second appeal. However, as with any other law and act, RTI has its challenges. Like backlog of appeals. Issues include a huge backlog of second appeals, lengthy wait time for hearings, hesitancy in posting penalties, and increasing opacity in the working of the commissions. As of June 2021, 2 lakh 56 256 lakh appeal were pending with 26 information commissioner in the country. CICS downgraded rank. That's the second challenge. Any serious RTI query or one which concerns more than one government department requires intervention by higher officials. But it is the PIOs from junior ranks who attend hearings and are often clueless. Often it requires a notice to higher authorities, in some cases, the secretary of the department, to elicit the right answer. With CICS downgraded in rank, there will be fewer and fewer notices served to the heads of departments and senior officers to appear and answer queries. Vacancies. The commissions have been plagued with vacancies. Poor choice of commissioners, untrained staff, and a non cooperative set of public information officer PIOs. Threat to some RTI activists. Apart from the PIO's general inexperience and unprofessionalism, comes the threat to some RTI activists who seek information to expose corruption. According to the Commonwealth Human Rights and Initiative, across India, 99 RTI activists have lost their lives, 180 assaulted, and 187 were threatened since 2006. Political proclivity. The attitude of a few commissioners going public with their political proclivities is another cause for concern. Now, after all this, the conclusion is that even when RTI, Right to Information Act, implementation appears less than ideal, positive impact can still occur. Passing RTI laws does not ensure more transparent, accountable, and inclusive governance and long term development outcomes. And the nature of the drivers of effectiveness and challenges to effective implementation varies by country. In general, a strong legal framework provides a good starting point and enabling conditions within a country. Strong demand for access to information, institutional capacity for implementation of RTI, and strong monitoring and independent oversight all drive effective implementation of RTI laws. State society collaboration, technology, and intergovernmental collaboration may serve as amplifiers or accelerators of RTI implementation. Of all the domains of RTI implementation, institutional capacity appears the most important, but each component work with and reinforces the others. The drive for effective implementation must come from within countries, and a national coordination strategy may comprise a valuable tool to aid implementation. That's it for this video. Thanks.